Even a Georgetown constitutional law professor who has publicly questioned the oversight panel's jurisdictional standing and written pieces favorable to Trump's legal position said this week, whatever one thinks of the panel's standing, two irreconcilable medical documents in the same proceeding is an evidentiary problem that can't be explained away procedurally. When someone on the opposite side of the debate says that, it's worth sitting with. Hensley held up both documents physically in open court. Addressed Callaway directly. Asked him to explain. He couldn't. 7 minutes later, he came back with a request for more time. She denied it. Then she ordered a joint evidentiary timeline due Friday at noon, every document, every signature, every date. She placed the contempt question in active consideration, not tabled. She requested a sworn White House medical unit representative available for questioning by July 1st. That took 11 minutes. While coverage fixated on the visual, something else happened in the same session. Bondi's office filed a supplemental notice, 2 pages, quiet at the bottom of the docket. DOJ has additional medical records beyond what was produced Tuesday. Those records are currently under privilege review. Hensley saw it, asked DOJ counsel about it directly. They said they couldn't characterize the records without completing the review. Her response, July 3rd deadline. All records, privileged or not, submitted for in-camera review. She'll look at them privately and decide what stays. That's not standard. A judge orders in-camera review rather than letting the parties resolve their own privilege disputes when she doesn't trust that the privilege claims are being made in good faith. That's the read from a former federal prosecutor who spent 11 years in DOJ's public corruption unit and tried 4 contempt cases against public officials. A former SDNY assistant U.S. attorney, now a criminal defense attorney, put the physician gap in sharper terms. Medical declarations submitted to federal courts require a verifiable signatory. If that physician's credentials don't hold up, the declaration itself could be struck. Everything built on it collapses. And if the declaration gets struck, every postponement granted on that basis gets reviewed retroactively. The contempt argument gets significantly stronger. About 8 months ago, the Federal Oversight Panel began requesting voluntary testimony from Trump on a financial disclosure matter. Routine on the surface. About 5 months ago, Trump's legal team started citing health concerns as grounds for postponement. First request, granted without controversy. 3 months ago, second postponement request. The panel pushed back quietly, still granted it, but internal correspondence later released through FOIA showed growing skepticism. Someone on the panel wrote in the internal minutes, "We are no longer satisfied that the stated medical grounds reflect the actual situation." Nobody picked that up. The pattern from there, delay requested on medical grounds, delay granted without documentation review, delay requested again on same grounds, documentation finally demanded, documentation produced by DOJ. DOJ's records don't match what Trump's attorneys filed. Every cycle, the medical rationale held just long enough. Until Tuesday, when 2 sets of records sat side by side in front of a judge who'd seen that move before, and she asked the question herself. Within 3 hours of Tuesday's session ending, he posted on Truth Social. Called the proceeding a weaponized medical inquisition run by Bondi's rogue office. Said the documents were stolen and misrepresented by judicial activists. The oversight panel's attorneys screenshotted the post and submitted it to the court record Wednesday morning. Legal commentators across the political spectrum flagged it as potentially relevant to the contempt analysis. Public statements attacking proceedings while contempt is actively being weighed. Trump's camp, separately from official legal counsel, walked it back within an hour. A spokesperson said the post reflected understandable frustration and wasn't meant as a formal legal position. Then Tuesday night, Callaway filed a motion to have Hensley recuse herself. Cited a 2021 speech she gave about executive accountability as evidence of bias. She denied it Wednesday morning. 2 paragraphs. No extended explanation. Filing a recusal motion during active contempt consideration is not going to make Friday's submission look like good faith cooperation. The physician who signed the health declaration hasn't been identified. Trump's team hasn't confirmed who it is. Friday's joint evidentiary timeline will almost certainly require it. What's in the additional records DOJ flagged in the supplemental notice? If they support the limitation declaration, this looks very different. If they support the progress notes, the timeline accelerates. And the question worth sitting with: Bondi's office produced these records. Whoever made that call knew what was in them. That's not an accusation. It's just the fact of it. The core legal question being established here: can medical documentation be used to indefinitely delay compelled federal testimony? If Hensley finds contempt and the Friday response falls short, the answer becomes formally no. Not without rigorously verified medical evidence. Courts cite each other. That's how law works. Right now, roughly 340,000 federal civil cases are active in U.S. district courts. Medical documentation is submitted in a significant portion of them. If this case establishes tighter verification requirements for medical declarations, legal analysts say you'd see the effects in processing time and evidentiary standards within 18 months. If the physician credential gap holds, and that doctor's credentials don't clear, sworn medical evidence was used to obstruct federal proceedings. That's not a procedural technicality. That's fraud on the court. Friday, June 27th, noon. Joint evidentiary timeline due from both parties. This is the first hard signal. Tuesday, July 1st. White House Medical Unit sworn representative availability deadline. Thursday, July 3rd. All additional medical records due for Hensley's in-camera review. Week of July 7th. Contempt ruling expected, pending Friday's submission. Not yet confirmed whether Callaway intends to file for emergency appellate review of the in-camera order before July 3rd. That would be the delay play, and it would tell you whether they have a legitimate answer to the physician credential question. Wednesday. A federal courtroom in Washington. A sitting president's medical claims got contradicted on the record, in open court, by documents his own Justice Department produced. Here's what I found after spending Tuesday afternoon with the actual filings. 47 pages. Read them twice. Most coverage missed the part that matters. Trump is currently in a civil contempt proceeding tied to health disclosures, submitted to a federal oversight panel earlier this year. The core issue: sworn statements about his physical condition appear to conflict with medical records the Justice Department inadvertently placed into evidence. Quick timeline. Several weeks back, Trump's legal team filed a formal health declaration and used it to justify missing 2 scheduled testimony appearances. The oversight panel pushed back, said the delays weren't medically supported, and asked DOJ to produce the underlying records. Bondi's office complied. Whether that was strategic or an oversight, nobody's confirmed yet. That's when the problem started, because the records DOJ turned over didn't match what Trump's attorneys had been telling the court. Not slightly different. The clinical conclusions were opposite. The health declaration, filed 11 days ago, states on page 9, the patient exhibits significant cardiovascular limitation precluding extended periods of physical or cognitive exertion without medical risk. That's clinical language, specific, intended to carry legal weight. Trump's attorneys were arguing he couldn't physically sit through prolonged testimony sessions. Then there's the DOJ document production. Page 31. The physician's internal progress notes from the same examination period. Patient demonstrates age-appropriate cardiovascular function. No acute limitations identified. Activity restrictions not recommended at this time. I went through that section 4 times. The gap isn't interpretation or framing. The conclusions are opposite. Both documents are now in the same court record. Page 44, footnote 7. The physician who signed the limitation declaration isn't listed in the White House Medical Unit's official personnel roster for the period in question. 19 months of records. His name doesn't appear. The doctor, who provided the medical justification for missing federal testimony, may not have been the treating physician on record. Judge Patricia Hensley flagged this publicly at 11:14 a.m. Tuesday. She's been on the federal bench 22 years. Former assistant U.S. attorney out of the Eastern District of Virginia. Her words, per the official transcript: "Counsel, I'm looking at 2 documents that cannot both be accurate. Explain that to me." Trump's lead attorney, Raymond Callaway, asked for a recess. 7 minutes. Came back with nothing. Said his team needed time to investigate the discrepancy and asked for a 48-hour continuance. Hensley denied it. Gave him until Friday. What started as a scheduling dispute now has potential fraud implications attached to it. 3 legal watchdog organizations filed amicus requests within 6 hours of Tuesday's session ending. The White House Medical Unit issued one sentence Tuesday evening: "We do not comment on matters before the federal courts." Within 24 hours, 2 news organizations reported that internal communications between the medical unit and Trump's private legal team are now being sought through subpoena. Both outlets cited separate sources. Trump's defenders, including some serious legal voices, argue this entire proceeding is politically constructed, that the oversight panel was never acting in good faith, that the medical documentation dispute is being amplified beyond what the law actually requires. Some of that holds up. First, executive medical privacy. Presidents operate under disclosure constraints that aren't fully settled law. There's legitimate debate about how much health information a sitting or former president must submit to an oversight body, especially one whose jurisdictional authority has been challenged in 2 prior filings, neither of which was fully resolved. Second, Trump's legal team is now arguing Bondi's office released these documents without proper privilege review, that the records causing the problem shouldn't be in the court record at all. Former White House counsel Bradford Simmons, who has represented clients across both parties, put it plainly: procedural production errors don't become substantive admissions. The origin of these documents matters legally. Hensley didn't have to order in-camera review. She could have let Friday's filing play out and ruled on what was submitted. She went further. She wants to see everything herself. That's a judge who thinks the document problem is bigger than what's visible in court. I'll be back when Friday's filing drops. Same approach. Documents first, page numbers, direct quotes, plain English. Not the headline version.